Roger Schuler, please.
This is he.
Hey, this is Sergeant Moore, Shelby County Sheriff's Office. Just to tell you.
Yes, Sergeant Moore, I appreciate you calling.
No problem.
Deputy Stockman gave me your name. He came and took an incident report at my home last Saturday, a week ago, and I was assaulted by a neighbor hit in the back with a for sale sign, you'd call it. And I filed the report and went down to Columbiana on Monday to get the report, and Deputy Stockman did a good job with the report. It was very professional, but he put it down as assault third degree, and I don't think that's correct. He and I just talked about it, and he explained to me his thinking, but he and I didn't come to a meeting of the minds on it, so he suggested I call you. And
that, from what you just described, is going to be a misdemeanor assault, because to qualify for a felony assault, there has to be a serious physical injury or means of a deadly instrument, and it's not going to fall into either one of those provisions for the statute.
Well, that's where I disagree. You may be out somewhere and don't have it in front of you. Before I ever did anything, I went to the law library the other day and I read the entire section on assault. I've got a copy of it, and the clear authority here is section 13A-6-21, which is assault second degree. And under item number 2, it says, I can read it to you if you don't mind. It's very short.
Oh, actually, hang on one second. I've got my copy.
Maybe you'd rather read it along.
Yeah, because I'm pretty familiar with the assault codes. Yeah, because see, on an assault second degree, if it causes physical injury, it has to be by means of a deadly weapon or dangerous instrument.
Yeah, a dangerous instrument, which is a
for sale sign is not going to qualify for that.
Yes, it is. I've got case law that says something as little as a pencil. It's dependent on how it's used, and it was hit. He swung it like a baseball bat and hit me in the middle of the back with it. This is a sign that is 3 feet by 2 feet. It's made of wood and plastic, and the law says any substance can be a dangerous instrument depending on how it's used. And this was hit me in the back, my back turned, walking away, swung like a baseball bat with 2 hands by a grown man. Using the word man loosely. And I've got case law here. In fact, this was in Shelby County a few years back, Berger versus State, where I guess a Pelham police officer was just kicked in the shins by a woman, and that was determined to be second degree assault.
Well, if it was a police officer, that's because it was in the performance of his duties.
Well, no.
If you assault a police officer, generally you will get assault second.
Well, the entire case says it's broken down into the different contentions under the law, and they said that qualified as physical injury enough to merit second degree. Just a sore shin. I mean, he was kicked in the shin. I'm sure it hurt like heck. He said it did. This hurt like heck. It bled. I got an abrasion on my back, and it doesn't require serious physical injury. One of the problems here is everybody agrees it's assault. Everybody agrees it's not first degree assault. It does have to rise in all instances to serious physical injury. It's not first, but it's also not third, because I'm looking at that now, item number 3 under that, if you involve a dangerous instrument, I agree it's not a deadly weapon, but a dangerous instrument, it has to be criminal negligence. And this was not negligent. It was not a case of him, he happened to be swinging a sign around crazily, he was drunk or whatever, and I happened to run into it.
No, I mean, if you look at section 2, it says if he causes injury by means of a deadly weapon or dangerous instrument, which I don't believe that would actually qualify in this case.
I'm sorry, which section are you talking about?
Section 2. Because if you read
under assault third degree?
Under assault second.
Okay.
Look at 13.621 subsection 2.
Right.
Because what that is intended for under assault second is if you use, any kind of deadly instrument, knife, gun, anything like that, but you don't cause serious physical injury. Like if somebody's coming at you with a knife and trying to stab you and they just end up cutting you on the finger or something, then that would qualify for assault second. That's what that statute is used for. Because you have have to have a deadly weapon and serious physical injury for the assault first.
Sergeant, can we please just read? It says a dangerous instrument.
Right.
And I've looked up the case law. That can be anything as small as a pencil, depending on how it's used.
That's true, depending on how it's used.
Well, this was 5 times bigger than a pencil, and he swung it and hit me in the back.
Right. But
that's a dangerous instrument, and it caused. Pardon me?
Generally, that's not going to qualify. I mean,
I don't care about generally. I'm talking about my case.
I understand that. Okay. If you use a pencil and stab it in somebody's eye, that's a lot different than throwing it in their head or something. If he had done if he had rammed it in your eye socket or something like that, then it would qualify.
No kidding. That would be first.
Right.
But that's not second. That's first.
Well, depending on the injuries. If it was serious.
Well, I think if somebody jams something in my eye socket, that's going to be pretty serious.
Right. So we're talking hypotheticals here, okay?
Yeah, but I don't want to talk. I just want to talk the law as it's written here. Number 2.
And no, sir, I don't think it's going to qualify for assault second. Just based on my experience with the DA's office, I do not believe it's going to qualify.
Well, that's fine. We can talk about it till we're blue in the face, but I'm not interested in what people think. I'm interested in the law being applied as it's written. Deputy Stockman said sort of the same thing. Based on my experience, his experience, I don't care.
Right.
I'm concerned about my experience and what the law. The only way the law.
In this situation, it would be assault third. Yes, sir.
Can you explain to me how?
I believe it would be assault third.
Well, I'm not asking what you believe.
I don't believe that it would qualify for a dangerous instrument or deadly weapon in this instance.
Sir, anything, any material. Would you please just apply the law? The law says, I've got the case right here, Berger versus State, and there's umpteen, that any material, it says any material can be a dangerous instrument, depending on how it's used.
Right, and I understand you're citing one case, but
I've seen other cases. This is just the one I've happened to get here.
But I can cite cases where, I've been assaulted also, and actually had physical injury, and they wouldn't even give me assault second. I've had a broken finger that didn't qualify as assault second.
Well, again, I'm not interested in past cases unless they go to state law, and as you know, case law, how the Alabama Supreme Court determines I guess the Court of Criminal Appeals here. I'm sure all kinds of things happen wrong down there. I'm sure there are people that, Deputy Stockman told me, that people that come down there and they get third degree and they don't know the law and they just go along with it. Well, I know the law. I've read it. And I just want it applied the way it's written. I don't want special treatment. I want it applied the way it's written.
In this case, I don't believe it would qualify for assault second.
Well, all you got to do is read a simple declarative sentence. And read what the case law is. You say yourself, a dangerous instrument can be anything, a pencil.
Yeah, it depends on how it's applied. But I do not.
It was hit me in the middle of the back, and as the law says, it caused a physical injury.
But I don't believe it qualifies as a deadly instrument.
It doesn't have to be a deadly. It says a dangerous instrument. You're mixing up.
Or a dangerous instrument, and I don't believe that it would qualify in this instance.
But no matter what the law says.
Well, I'm just telling you how I interpret the law.
Well, I'm just telling you all are wrong. I mean, just please, all you got to do is just read. I can read.
I mean, if you disagree with me, you can refer to my supervisor who will be here on Monday.
Well,
take it up with me.
How many people am I going to have to talk to? Who is that?
I'll be Lieutenant Brogdon, and he will be in probably first thing Monday morning.
Lieutenant Brockman? I'm sorry?
Brogdon, B-R-O-G-D-E-N.
B-R-O-G-D-E-N.
Be like Bravo.
Okay.
B-R-O-G-D-E-N.
Brogdon. Okay.
Yeah, well, he usually works Monday through Friday, so he should be in first thing Monday morning.
And well, I appreciate talking with you. I don't intend to get, but I think you all see so many cases, and I'm sure sort of things become almost folklore. I had Lou Lawley. I was in her, or Lou McElroy, I guess her name is now. But she first said, "Well, you weren't taken to the hospital or anything." I said, "No, but that's you don't have to be taken to the hospital." I mean, I think people you all deal with it day in and day out. I know it gets tiresome to see people assaulting one another, and it just becomes people think. But yeah, I just want the law applied as it's written. We elect representatives to go down to Montgomery and write the law that's supposed to apply to all Alabamians, and that's all I ask. I'm not asking for special favors.
As far as the prosecution and that kind of thing, that would have to go through the DA's office.
So I understand that.
Even if, it doesn't really matter what we write on the report, because the DA's office is the one that's going to end up, they drop our charges all the time and file their own. So,
well, I talked to Bill.
It would be up to them to prosecute it.
I understand. I'm kind of getting the runaround. Bill Bostic, I talked to him yesterday, and he referred me to the sheriff's office. He claims you all determine whether it's second or third. And I thought that sounded weird.
Because the DA's office is the one that's going to issue the warrant to you. Because you're the one that's going to go in there and sign the warrant on it. And they're the ones that sit down and screen. Like, we can't even make a felony arrest. I mean, we can make them, but we have to get them screened through the DA's office. Any felony arrest we make has to go through the DA's office.
Well, yeah, that's what I would think. He suggested I call Jeff Cardwell, an investigator, and I've emailed him. I don't know if he's gotten back with me or not.
Yeah, he should be at work Monday also.
Okay.
He's going to be in the supervisors of the investigator division.
And one of the key, you probably don't have the report in front of you, but there is an eyewitness to all this too. I mean, it's not my word against his. A woman saw this. She said, I've talked with her. She said, I saw the two of you conversing. I saw you walk away, and I saw him slug you in the back.
Right.
And it left a welt on my back, and it's, like I said, if you read I just don't want it applied, well, I've seen this case and that case, and history says that. I just want it applied to my case the way it's written. I mean, that's the way the law is consistent if we follow it the way it's written.
Right.
And as opposed to somebody's...
I don't believe it would fall under this subsection 2.
Well, you're entitled to your opinion, but I want to get it right. And you all have handled it fine. I'm not personally a problem with you or Deputy Stockton, either one. I just think you're mistaken. I make mistakes, and I just want the mistake corrected. So, and you've told me how I can do it, so I'll do that.